budget blueprint that contemplates cutting non-defense spending, including Homeland Security budget, by $500 million below the sequester level spending caps. In spite of budgetary constraints, the Department of Homeland Security has detained and deported more individuals than during any other period in its history. According to the Migration Policy Institute, roughly 1.95 million people were removed from the United States between 2008 and 2013, those 6 years. That's approximately the same number who were subject to removal during the 8 years of the Bush administration. In accordance with the guidance issued by Secretary Johnson last year, the Department also continues to conduct its enforcement and removal activities by prioritizing high-level threats to national security, border security, and public safety. Chief among the highest priority threats are undocumented immigrants suspected or engaged in terrorism or espionage, convicted felons, and those convicted of criminal street gang activity. DHS is also seeking to strengthen its ability to collect and analyze immigration data in response to the recommendations issued by DHS Inspector General Roth, who is a guest of ours today, in May of 2015 regarding how best to enhance enforcement efficiency. Specifically, the Inspector General's report notes that DHS agreed with the report's recommendation and plans to initiate a multi-pronged approach to gathering essential data on its use of prosecutorial discretion through its Office of Immigration Statistics. Secretary Johnson ordered the Department and its components to fully comply with the February 2015 injunction issued by the U.S. District Court for the Southern District of Texas to halt the expansion of the Deferred Action for Childhood Arrivals program and the creation of a Deferred Action for Parental Accountability program. In particular, Secretary Johnson announced on the day after the decision that DHS would not accept requests for expanded childhood arrivals and would suspend its plan to accept requests for the new Parental Accountability program. He has also requested that the Inspector General Roth investigate the issuance of approximately 2,000 expanded work permits by U.S. Citizenship and Immigration Services that were already in process but not halted quickly enough in violation of the injunction. And I understand the Department has been cooperating with the Inspector General's office thus far. So, Mr. Chairman, I look forward to discussing the progress of this investigation and other issues pertaining to our improving immigration enforcement with our panelists, and I yield back the balance of my time.
I thank the gentleman from Massachusetts. The Chair now recognizes the Chairman of the Health Care Benefits and Administrative Rules Subcommittee, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. I'll be brief. Here are the facts. As the Chairman indicated, 22 times the President said he couldn't do what he did. Federal judge agreed with the President what he said 22 times and said the executive amnesty order was, in fact, wrong. That judge has said attorneys for the government, when they came before the court, misrepresented the facts. And after the injunction, the Department of Homeland Security violated the judge's order when they sent 3-year work authorizations to approximately 2,000 individuals. Those are the facts. That's what we need to get the answers to. That's why I'm pleased our panel is here, so they can answer our questions. I think this is a hearing very necessary, Mr. Chairman. I appreciate the chance to be here. Appreciate you calling the hearing. With that, I yield back.
Gentleman yields back. The Chair now recognizes my friend from Pennsylvania, the ranking member on the Health Care Benefits and Administrative Rules Subcommittee, Mr. Cartwright, for his opening statement.
Thank you, Mr. Chairman, and thank you to our witnesses for joining us today. I look forward to hearing how the administration is working to uphold this nation's immigration laws. Following the issuance of the administration's executive actions on November 20, 2014, a lawsuit temporarily halted the rollout of new and expanded deferred action programs. The Department of Homeland Security trained its personnel and has begun implementing and working on new prosecutorial discretion policies, and U.S. Immigration and Customs Enforcement, ICE, prepared for the rollout of the new priority enforcement program. In the midst of all that's happened, I think some of my colleagues have forgotten the reasons for the actions in the first place. Our immigration system was and continues to be in dire need of reform. DHS faces 11 million undocumented immigrants and does not have the resources available to remove them all. Many of these individuals have been in this country for upwards of a decade, living in the shadows, raising their children, many of whom were born in the United States. The Senate passed a bipartisan comprehensive reform bill in 2013, but legislative efforts have ground to a halt in the House because of Republican opposition. In the face of legislative inaction, DHS issued a series of memoranda attempting to address the growing undocumented population. One memo provided guidance to more consistently focus resources on removing the most dangerous criminals and the most serious threats to public safety. Another memo announced efforts to improve the partnership between DHS and state and local law enforcement. Yet another memo modified deferred action policies in order to provide temporary stability to hardworking, peaceful immigrants who are willing to pay their dues. These executive policies attempted to solve problems, but the executive branch can only go so far legally, and the immigration system will remain broken until Congress passes a legislative solution. Republicans in Congress have been happy to challenge and question and criticize the administration for its actions instead of offering solutions. Now, given the recent Texas federal court injunction, it is my belief that USCIS Director Leon Rodriguez understands his responsibility to comply with the law and that he has worked quickly to halt the implementation of the new and expanded deferred action programs as soon as possible. I also appreciate that the USCIS has taken full responsibility for the release of work permits after the injunction was ordered, and I look forward to hearing today about changes at USCIS that will ensure that this kind of thing doesn't happen again. But while the courts hear the legal challenges to the administration's actions, and while Republicans in Congress criticize those actions themselves, the problems in our nation's immigration system persist. I urge that my colleagues across the aisle turn their efforts toward lawmaking and away from belly aching. Moving forward, I hope we can finally focus on comprehensive, lasting legislative solutions. This is the work and attention our broken immigration system and the millions affected by it so desperately need. I thank you, and I yield back, Mr. Chairman.
Gentleman yields back. Thank you. I will hold the record open for 5 legislative days for any members who would like to submit a written statement. We will now recognize our witnesses, and I'm pleased to welcome Ms. Sarah Saldana, Director of U.S. Immigration and Customs Enforcement, Mr. Leon Rodriguez, Director of U.S. Citizenship and Immigration Service, and Mr. John Roth, Inspector General at the U.S. Department of Homeland Security. Welcome all. Pursuant to committee rules, all witnesses will be sworn in before they testify. If you please rise and raise your right hands. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. All witnesses answered in the affirmative. In order to allow time for discussion, please limit your testimony to 5 minutes. Your entire written statement will be made part of the record. And with that, Ms. Saldana, you're up for 5 minutes. Thank you. Committee will come to order. Please have the police escort the protesters out. Committee will come to order. Committee will suspend. Protesters will leave the hearing room. We ask the people who are watching, watch, listen, learn, but if you disrupt the hearing, you will be removed. I now recognize Ms. Saldana for 5 minutes.
Thank you. I don't think I got to thank the ranking members, Cartwright and Lynch, and subcommittee members. I'm pleased to appear before you along with U.S. Citizenship and Immigration Services Director Leon Rodriguez. While Directors Rodriguez and I lead different agencies with certainly distinct missions, we are part of the same department and are very mindful of the necessity to do all we can to ensure coordination between our components. In the 2 months since I first appeared before the full committee, I have continued to take steps to enhance ICE's ability to achieve one of its primary goals, that of enforcing our nation's immigration laws and keeping our country safe by ensuring we focus our resources on individuals who pose the greatest threat to our national security and to public safety. Secretary Johnson has made it clear to all of us that our borders are not open to illegal migration and that ICE should allocate enforcement resources accordingly, consistent with our laws and with our values. As such, ICE is endeavoring to use appropriate prosecutorial discretion and dedicating resources to the greatest degree possible toward the removal of individuals who are considered enforcement priorities, which includes criminals and recent border entrants. Guided by DHS's enforcement priorities, the approximately 7,300 personnel of ICE Enforcement and Removal Operations, or ERO, identify and arrest and detain convicted criminals and other removable aliens. We, as appropriate, supervise them through alternatives to detention or remove them from the United States through our immigration courts. While there is still a lot of work to be done, I've seen progress in my 6 months leading this agency. First and foremost, our employees are dedicated to accomplishing this mission with integrity and with professionalism. As a result of their tireless efforts focusing on the priorities I mentioned, they are making our communities safer. We are now removing a greater percentage of criminals than we have in the past, and I'm committed to continuing this trend. In fiscal year 2014, 85% of individuals removed or returned from the interior were individuals previously convicted of a criminal offense, reflecting a significant increase in the rate of removal of individuals with convictions, from 67% in fiscal year 2011 compared to 38% in fiscal year 2008. The increasing number of convicted criminals removed from our country is the result of the change in ICE's strategic focus, which revised policies and your initiatives have helped us achieve. That's why I, along with our employees at ICE and the leadership of the department, have been working hard to implement the new Priority Enforcement Program, PEP, where we engage state and local communities to enhance the agency's ability to remove dangerous individuals. Recently, both the counties of Los Angeles and Contra Costa in California agreed to continue cooperating with ICE and DHS in implementing PEP. We anticipate they will be the first of many. That's also why I've been working to bolster ICE's ability to obtain travel documents from recalcitrant countries, a problem I know this committee is familiar with. I'll continue to work closely with the Department of State to achieve better compliance from countries in accepting the return of their nationals. I should also mention my establishment of enhanced oversight and release procedures for ICE custody determinations involving detainees with criminal convictions on their records, to include developing a capability to provide appropriate criminal alien release information to state law enforcement authorities and relevant jurisdictions. I put this procedure in place to enhance public safety and greater public confidence in ICE's enforcement and administration of immigration laws. Part and parcel of this effort is a law enforcement notification system currently being used in Virginia, Louisiana, and my home state of Texas, in its early stages currently, and which we expect to be fully implemented across the country sometime before the end of the year. With respect to family residential centers, last month I announced a series of actions to enhance oversight over these centers, to increase access and transparency, to ensure that they continue to provide a safe and humane environment for detained families. While we routinely review and evaluate our facilities, all of our facilities, we understand the unique and sensitive nature of dealing with women and children in these settings. Even as we do this, however, We also cannot have an immigration system that encourages criminals to take advantage of people, to abuse women and children while they attempt to smuggle them into the United States. And both ERO and HSI are working together to find and dismantle and bring to justice these organizations. As we move forward, I believe that ICE will be successful in the deliberate implementation of our mission objectives. I look forward to working with this committee, and I echo the sentiments of the Congressman with respect to reform of the laws which are encompassed in this book along with the regulations. This is a very complex system that needs to be reformed.
Thank you. Gentlewoman's time has expired. The Chair now recognizes Mr. Rodriguez for 5 minutes. You're up.
Good afternoon, Chairman, ranking members, and members of the committee. Thank you very much for inviting me to be here today. I have talked about my own personal story before. I am the son of Cuban refugees from South Florida. I have talked often about the sufferings that led them and my grandparents to make the choices to come here to the United States, and the hopes and dreams that they brought with them when they came here. This has taught me, as director of USCIS, that every file we see, whether it is a DACA request, a naturalization request, a refugee filing, a worker visa filing, that all of these cases represent one family's hopes and dreams, and in many cases, that family's sufferings. I believe deeply in the work that we do at USCIS. And I believe in it because it requires us, both from a perspective of immigration policy and operating the immigration system, to answer fundamental questions about our country. Will we be a prosperous country, or will we not? Will we keep families together, or will we allow them to be fragmented and destroyed? Will we be guided by the rule of law, or will we not? Will we protect the national security, or will we not? Will we lead when there are issues, or will we just watch as those issues deepen, become worse, become problems, and even crises? Unfortunately, for too long, our political system failed to answer these questions with respect to a number of aspects of our immigration system. Not simply the situation of those who are here in an undocumented status and the many members of their families who are here legally, but also those aspects of our immigration system that bear critically on our economic prosperity and our civic stability. It is for this reason that the President issued his executive actions back in November of 2014, focusing on promoting integration of immigrants, promoting actual accountability of those who are here in an undocumented status, a condition that did not exist before the President took that step, and promoting within the confines of what the law allows him an immigration system that fully promotes our economic success as a country. The President was building on the success of the 2012 DACA program, and there are many success stories, young people who have become teachers, nurses, doctors, in one case now even a lawyer, and who really demonstrate the potential that they have to contribute to the United States. Our work was enjoined by the court in Texas. The one thing I'd like to underscore about that is that it's not over until it's over. We believed in the legality of our policies, and we believe that in the end we will be vindicated by the legal process. Nonetheless, when the court issued an injunction, I, as the director of USCIS, as an attorney and as a former prosecutor, ordered the immediate cessation of all activities to implement the deferred action policies under the President's executive actions. One of those actions was to stop the issuance of 3-year work authorizations that had actually been granted the week before the injunction was issued. Unfortunately, through a miscommunication, those work authorizations were issued anyway. I have taken full responsibility, both in this forum and before the court. And to say that I took it before the court is to say something significant. I am an attorney, I am a former prosecutor, and I have said very clearly to Judge Heenan, I am responsible, I am accountable for what my agency did. The question now, though, is as I take accountability, will we as a political system take full accountability for the challenges that we have in our immigration system? The President made it very clear at the time that he issued the executive orders that they could be stopped immediately if instead we found a legislated solution to the ongoing, now decades-long challenges presented by the undocumented, presented by the insufficiency of our immigration system to meet our economic needs. I stand here today ready to work with all of you to work toward those improvements. Thank you, and I look forward to your questions.
Thank the gentleman. Chair now recognizes Inspector Roth for 5 minutes.
Good afternoon, Chairman Jordan and DeSantis, Ranking Members Cartwright and Lynch, and members of the subcommittee. Thank you for inviting me here today to discuss DHS's collection of prosecutorial discretion data. DHS has instituted various policies over time that allow the use of prosecutorial discretion in making immigration enforcement decisions. However, the Department does not collect or use such data to help assess immigration policy, evaluate the effectiveness and results of enforcement actions, or be able to assess the reasonableness of the exercise of that discretion on the part of DHS personnel. Since DHS's formation in 2003, ICE has implemented various policies to focus its efforts on criminal and civil enforcement priorities. It has also used policies for processing aliens with special circumstances, such as crime victims and witnesses, nursing mothers and the elderly, as well as ensuring that enforcement actions are not focused on sensitive locations, such as schools and churches. At the time of our audit, ICE's removal actions were governed by a series of policy memoranda signed by then ICE Director John Morton in March and June of 2011, and focused its enforcement resources on 3 things. 1, aliens who pose a danger to national security or a risk to public safety. 2, aliens who recently violated immigration controls at the border and ports of entry or knowingly abused the visa process. And 3, aliens who are fugitives or otherwise obstruct immigration controls. Additionally, a year later, in 2012, the Department issued guidance known as the Deferred Action for Childhood Arrivals, known as DACA, which allows the use of prosecutorial discretion to defer action or release some aliens who came to the United States as children and meet other criteria. Despite its reliance on discretion to prioritize enforcement resources, ICE often does not collect prosecutorial discretion data and does not always ensure that its statistics are accurate and complete. For example, ICE records its use of prosecutorial discretion broadly, without distinguishing the various types of exceptions to removal, such as DACA-related exceptions. Additionally, prosecutorial discretion statistics may be inaccurate because enforcement officers may not document every encounter with aliens it considers to be a low enforcement priority. ICE officials told us that field personnel often do not record their use of prosecutorial discretion because it is too time-consuming. As a result, data to support decisions on the use of prosecutorial discretion may not be available. DHS should ensure it can support its decisions with solid data. A feedback mechanism for the use of prosecutorial discretion could help DHS identify gaps, set goals, determine budget requirements, and provide information to improve program performance. In terms of overall immigration enforcement policy, such a mechanism could help develop sound future programs and policies. In addition to assisting in the overall policymaking process, capturing the right information would allow the Department to ensure that the proper and even-handed application of the policies exist. As it stands now, there's no mechanism by which to assess the reasonableness of an individual officer's exercise of discretion, to compare prosecutorial discretion decisions for similarly situated aliens, or to compare the use of prosecutorial discretion by various field offices. This data, if collected, could also be used to evaluate the performance of individual officers or field offices. Uneven or inconsistent policy enforcement can have a negative effect on DHS's immigration enforcement mission. Here, because the Department does not collect data on, much less monitor the use of prosecutorial discretion, we are unable to determine whether the Department is using prosecutorial discretion consistently or fairly. The Department agreed with our recommendations in our audit to improve collection, analysis, and reporting of data on the use of prosecutorial discretion. DHS is planning a multi-pronged approach for assessing and accounting for its immigration enforcement efforts. We believe such a strategy is particularly important given that over the last 2 fiscal years, ICE, CBP, and USCIS collectively received, on average, about $21 billion annually for immigration enforcement. Chairman DeSantis and Jordan, this concludes my prepared statement. I'd be happy to answer any questions you or members of the committee may have.
Thank you, Mr. Roth. Chair now recognizes himself for 5 minutes. Ms. Saldana, you recently reported to the Senate that 121 illegal aliens that have been released by ICE between fiscal year 2010 and 2014 have been arrested for homicide since they were released. How many total homicides have these 121 individuals been charged with? Can you hit your microphone, please?
Beyond the specific information we provided with respect to the homicide, I think we broke down the information. I can't tell you whether there were other homicides involved.
So you just know that those folks have been charged with a homicide, but it doesn't rule out that they could have been charged with multiple homicides. Is that correct?
I can't say we're sitting here today that that's not the case.
And do you know at this point how many convictions have resulted from those charges?
No, I don't.
Is that something that you're interested in finding out?
Certainly. I think we have, as the Inspector General has pointed out, we're working on our systems to try to be more flexible and responsive. We get a lot of inquiries in all shapes and sizes, which we're trying to make our information system more flexible, and that's taken a little time. But yes, absolutely, we're interested in that information, like I know you are, sir.
Do you know if any of those individuals had been convicted of a homicide-related offense before they were released by DHS?
I do not have that information. I don't believe that's the case.
But that's obviously something that's important to know. What, if any, changes does ICE plan on making in light of the fact that you do have 121 individuals who were in ICE custody, were in the country illegally, have been released, and now have been charged with committing homicides? And just the way our criminal system works, I mean, most people who get charged end up getting guilty. I mean, it's probably over 90%. Let's just say it's 60%. That's a lot of people who've been killed. That's a lot of families who've lost loved ones. And they can look at ICE and say, look, had you just done your job better, maybe my family member would be here today. So what policy changes are you going to make to prevent that from happening in the future?
And I will say that is particularly disturbing, I know, to all the members of this committee and to myself as a prior U.S. attorney in North Texas and Dallas-based. That is something that we're always trying to do, is to find criminals and to convict them. As a result, when I first came here—
Well, and you probably did that very well. I know people on the state level in Texas and other places do it very well. The problem, though, is if they're going and they're being convicted, and then ICE knows that they're not here legally, and we know they're convicts, and yet they still get released into society. In 2013, I know you were an ICE director then, 2013, DHS released 36,000 individuals who were in the country illegally, had been convicted of crimes. They provided the crimes to us, and they included homicide, they included rape, they included drug trafficking, some very, very serious offenses. 2014, you had 30,000 individuals, again, who were in the country illegally, convicted of crimes, and yet still released by DHS. And so the local and federal law enforcement officers and the prosecutors, they play an important role. But if DHS is then going to release people who've been proven to be a danger to society into the public, well, then that leaves more Americans to be victimized by, in some cases, very violent crimes.
And that's why, Mr. Chairman, I established a procedure that I announced back in March for greater oversight over the release of any person who had a serious prior conviction. In particular, I'm asking people to sign off a piece of paper, the original person who makes the determination with respect to either custody or bond. I'm asking their supervisors to review it. I've actually put together a panel in headquarters which looks over all of these decisions to determine whether or not they were based on the facts and circumstances known to the individual and that they were right decisions. As I mentioned earlier,
And if they're not right decisions, what happens? Because I mentioned the 36,000 in fiscal year 2013. So these are folks that have been convicted in our courts of, in many cases, very serious offenses. They weren't in the country legally. They're released. And now, even at this point in 2015, of those 36,000, by DHS's own figures, 1,000 of those people have already been convicted of new crimes again in the future. And so clearly there is a breakdown there. So when that is not followed, what happens? Who is held accountable? Does anybody lose their job?
It could be, sir. We'll just have to see.
Has anyone lost their job since you've been ICE director?
Not yet. No, not in the
So
6 months.
So the 1,000 new convictions that we've seen for people who had already been convicted, there's not been any accountability within ICE for that. To me, that's a major failure, because if I were somebody whose family member was victimized by a crime, I would want to know, well, wait a minute, you guys should have known the president's policy is, we're going to go after the criminals, zero tolerance, we're going to make it happen, and yet that hasn't happened. So what do you say to the families who've seen who've been victimized?
If I may, sir, I would say that those are tragedies, and I wish that our deportation officers and others making these decisions were omniscient and could see into the future and into the heart and soul of these individuals. But we go by the facts that we know.
Criminal conviction for, say, aggravated assault, that's not looking into the future, that's looking into the past. I mean, as a prosecutor, if you have people who run afoul with the law and get convicted of violent criminal activity, those are people that are much more likely to commit crimes in the future than somebody who's never committed a crime in their life. So it's not just saying that this is all just trying to look into the future and you need clairvoyance. You can judge whether somebody's a threat to society based on their past conduct.
If you'll allow me to finish my answer, Mr. Chairman, I would really appreciate it, because I think the American people have a right to know the full picture here. Every decision we make, there is not a single deportation officer or other agent with an ERO who wants to let a dangerous criminal out in the streets to threaten the public. I can guarantee and assure you of that. They are law enforcement officers. And with respect to the ability, we've got to look at the record as it is. We don't look at one single factor. We do look at the age of just like a court of law, the federal courts in which I practiced. They look at many different factors and determine whether to release an individual. And we are bound by some of the numbers that you threw out by the Supreme Court in its decision with respect to not being able to detain people beyond 6 months typically, and the immigration courts that set bond and release some of these folks as well. So that is the complete picture, and that's what I can assure you of, is I'm committed, and I have been doing this since I stepped into this position back in January, to keep that number down and to try to avoid future tragedies like the ones you've described.
Point taken. Now, you said that there are multiple factors, so you can't just look at one thing. So maybe someone has a blemish on their criminal record, but there's other factors. You mentioned age. Answer me this, because there have been people that have been convicted of sexual assault who have been released, and by ICE's own admission, it wasn't because the 6 months was up. Sometimes that happens, but there are other people who did not, where they were discretionary releases. So what other factors would outweigh a conviction for a sexual assault against a woman or a child? And why would we want that person in our society?
This Congress, and in this elaborate system that we're talking about, has entitled the individuals to bond and have said things like the age of the criminal conviction, the nature of the crime.
No, I understand that, but how does that outweigh the seriousness of the offense when you're talking about people who've committed sexual assaults, crimes against children, crimes against women? That's what I don't understand. I understand if somebody got a speeding ticket or something, but some of those, I think there's broad agreement in the American public that that is not something that we want to see where ICE is facilitating people to go back on the street. Now, I'm over my time, so I appreciate you answering the questions. I know some other my colleagues will have more, and I am going to now recognize Mr. Lynch for 5 minutes.
Thank you, Mr. Chairman. You know, the way we approach the question, the wider question of immigration, is really based on what narrative that we use. This committee, this hearing, is set up on a narrative that really looks at illegal immigrants who have committed heinous crimes, homicides. And so someone using that narrative will have a very negative view towards immigration policy, because you're looking at that consequence. There's another narrative, though. I had an opportunity as part of this National Security Subcommittee to visit with the former chairman, Mr. Issa. We went to Kandahar, Afghanistan. And I was honored. I have to say I was honored to be asked to participate in an immigration, a citizenship ceremony. So here I am at this godforsaken forward operating base when about 100 young Marines, men and women, surprised at the number of young women, took the oath of citizenship for this country. Every one of them a non-citizen, in American uniforms, fighting for this country in a very difficult war zone from 19, and out of those, about 100 Marines, a few soldiers as well, 19 different countries, from Guatemala to Somalia to Ethiopia to Mexico. And I was standing there, and we had a chance to spend the afternoon with these young soldiers and Marines, and I could not help but think about the quote that John F. Kennedy made famous. He said, "Ask not what your country can do for you, but ask what you can do for your country." And I'm thinking, these young soldiers, these young Marines, standing in the place of American citizens in a tough war zone, chasing the Taliban up and down that province, and they're not even citizens. Trying to be American citizens for all the right reasons. If you take that narrative and you see the good that is possible by adopting an immigration policy that actually values that desire to be part of this country for all the right reasons, you take a whole different, a much more hopeful view of immigration policy and what we could accomplish if we got it right. So, Ms. Saldana, Director Saldana, I want to ask you about some of your comments earlier. You're talking about, look, we all know that if we got sequestration, or even the proposed budget is $500 million below sequestration, which really cuts into your ability to do your job. And I've seen numbers that say that 85% of ISIS removals from the United States in 2014 were convicted criminals. So it sounds like you're meeting your priorities. I'm just wondering what impact is this going to have in going after your priority? You said it was national security, so that's going after terrorists and those involved in espionage, criminal activity. So how will this, tell me a little bit about how this might affect your ability to do your job and to try to make sense of this somewhat dysfunctional immigration policy that we have right now?
Well, I'm glad you asked that question because we have had a number of things working against us and increasing our expenses. For example, obviously the influx of families, women and children, require even greater services than others. Those beds are much more expensive than a regular adult bed that you would have. We have operations that we conduct because we cannot get people from the state system immediately, with some jurisdictions not cooperating with us. We have operations we have to conduct where we pull people off of their regular duties and go out and try to find dangerous criminals. That not only exposes the officers to safety issues, but it also can be a very detrimental situation with respect to the family who is present at the time that the officers show up. So to us, even the disruption that occurred back in March, before March, with respect to not having even any kind of guarantee with respect to our 15 budget, it wreaked tremendous havoc, never mind the 20,000 employees who would not be receiving a paycheck if sequestration continues in this manner.
Right. Now, do you do any work with the victims on the victim side?
Absolutely.
In these cases, and is that piece going to be affected as well?
Yes, and I'm glad you mentioned that because we often forget it's not just ERO, but it's HSI, our Homeland Security Investigation side of the house, that is affected by these budget constrictions. And they help us with respect to these smuggling networks, as I mentioned in my opening statement. Not only do we have to take care of the families once they get across, but we ought to do the best we can to dismantle those smuggling organizations that put them at peril and bring them over into this country. So yes, sir, that's a more complete picture.
Very good. Thank you. Mr. Chairman, I'll yield back.
Gentleman's time's expired. The chair now recognizes Mr. Jordan for 5 minutes.
Director Rodriguez, President issues his executive order on November 20th of last year. Court case ensues. There's a hearing on the preliminary injunction, January 15th, 2015. Your counsel represents to the court, no applications for revised DACA would be accepted until the 18th of February. No action would be taken on any of these applications until March 4th. Did you know at the time that your counsel was misrepresenting the facts?
No, and I'm not sure I would characterize it that way, Congressman. The fact was that beginning on November 24th, for individuals who were applying for either renewal or for
if I could just interrupt for a second, Mr. Rodriguez, it's pretty clear your counsel said, just to be clear, Your Honor, and he reemphasized that point that no applications going to the 3-year deferrals would happen until at least February 18th, or excuse me, March the 4th. And yet the case, isn't it true that you had 100,000 of these applications go, or not applications, but these actual 3-year deferrals go out to 100,000 individuals?
100,000 individuals under the original 2012 DACA program who were being granted 3-year work authorizations rather than 2.
Exactly.
I won't characterize my counsel's comments.
Well, I mean, the judges said it. They were misrepresented to the judge. I'm saying, did you know at the time the counsel for your side of the case misrepresented that fact to the judge?
I was not aware of the statement made by my counsel at that time.
When did you learn that there had been a misrepresentation to the court?
I learned that the court believed that there had been a misrepresentation in March when we first informed the court in an attempt to be 100% clear with the court, in fact granted roughly 108,000 3-year work authorizations beginning on November 24th, long before the lawsuit was even filed. And by the way, Congressman, openly.
Yeah. So you informed the court when?
We advised the court, I believe, at the beginning of March. It would have been something like March 3rd or March 4th, when of our own initiative, in order to be 100% frank and clear with the court, our counsel took the initiative to advise the court that we had
okay, you advised the court on March the 3rd or 4th, early March. When did you first learn that there may be a problem?
Immediately after the injunction, we discussed the existence of these 108,000 3-year authorizations. Again, individuals under the original 2012 program. This would have been sometime in the few days after the injunction was issued.
I'm looking for a date, because you got to remember the context, though, Director Rodriguez. We were having an important debate here in Congress relative to the Department of Homeland Security funding bill. The judge issues his injunction on February 16th. You're telling us a few weeks later we went on our own, just out of the kindness of our heart, even though the judge thinks you misrepresented the case to him, out of the kindness of your heart, you told the judge sometime early March, but that DHS bill came due on February 27th. You said you knew about this shortly after the injunction, so sometime between February 16th and February 27th, you learned of it. I'm wondering why you didn't tell us right away, or tell the judge right away, which we would have known about and the American people would have known about.
We told the court within a couple of weeks of the injunction in an effort to be candid with the tribunal, which our counsel felt that it was their obligation, and which certainly, had I been counsel, I would have had the same attitude as well. We wanted to make sure that the court understood that.
All I'm saying is it would have been nice in the heat of that debate, frankly, debate that the whole country was having, if we'd have had that information before the deadline of the DHS bill, which was February 27th. Well, and you're telling me you knew there could be a problem, and you decided to tell the judge, but you waited until after the 27th.
Congressman, I'm not sure I agree with the characterization. The fact is, we told, once we understood that this was an issue that the court may not have understood, we made the decision to let the court know. It was our intention at all times to be candid with the court, and what I underscore is that we had this up on our website. This was included in our filings with the court, that the directive was to issue 3-year work authorizations immediately. That was part of our initial response.
Well, I'll tell you what would have been a lot nicer. What would have been a lot nicer is if the counsel for your side, when they were in front of the judge, would have told them what you told the court. Would have told them, hey, there's already been 100,000 go out, instead of misrepresenting it to the court and saying that's not going to happen until sometime in February, sometime in March. That'd have been better. But the fact that you learned before the 27th date and waited to tell the judge and therefore Congress and the American people until after the DHS bill, I think is relevant. Last question, if I could, Mr. Chairman. Mr. Roth, have you looked into this issue?
We are in the process of doing the field work on this, yes.
And what does that mean, Mr. Roth? Is that going to be a report sometime soon, or when are we going to have something that, when's your investigation or audit going to be done?
Sure. We're conducting interviews as we speak, reviewing emails, doing the kinds of things that we would typically do. My projected timeline is hopefully weeks, not months, but I can't give you a firmer date than that.
Thank you, Mr. Chairman.
The chair now recognizes the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Mr. Chairman. Well, Mr. Rodriguez, I want to spend a little more time exploring USCIS's rollout of DAPA and expanded DACA, DAPA meaning Deferred Action for Parents of Americans. In light of the Texas Federal Court decision, Director Rodriguez, I understand you have taken great pains to comply with Texas Federal Court's injunction. Is that correct?
That is correct, Congressman. Immediately, literally, the court's injunction became known to us around 11:30 p.m. on President's Day. By 1 o'clock in the morning, we had issued a directive to cease all implementation of either the expanded DACA policy or the DAPA policy, including to halt any issuance of 3-year work authorizations.
Okay, so you immediately swung into action to enforce this injunction, right?
That is correct, Congressman, including rolling back materials on our website, forms, instructions, in order to absolutely comply in every respect with the court's injunction.
Okay. Now, I understand that DHS has admitted that some work authorizations were provided after the court's injunction was ordered, and your written testimony makes it clear, quote, USCIS also took immediate steps intended to ensure we ceased issuing 3-year work permits. Director Rodriguez, can you describe what those immediate steps were and why they didn't work?
The concrete immediate step that was taken was that all of those work authorizations that we're talking about were in what is essentially a giant print queue. What was supposed to, and so we halted them, and what was supposed to have occurred is that they should have been essentially reversed and sent back to the immigration services officers who were reviewing the case. Instead, there was a miscommunication which led those print orders to go to the contractor that actually prints the 3-year work, 3 or 2-year work authorizations, as the case might have been, and they were printed. We discovered this in the process of correcting other errors that we had made, and immediately notified on our own initiative both the states and the court. We have advised all of the affected requesters of the fact that they are getting 2 rather than 3-year work authorizations. We have required them to return their 3-year work authorizations. In fact, close to half of them already have.
And are there. So what you're telling us is that it wasn't that you got caught or somebody blew the whistle on you. You picked up the error on your own. Is that correct?
Well, let me characterize it. We caught ourselves.
Caught yourselves, and you reported yourselves.
That is
correct,
right? Congressman. Yes.
And that was all out of an effort to be candid with the tribunal in Texas.
That is correct. And also, frankly, to be fair with our customers and let them know exactly where they stood with respect to their cases.
And then you went to the people that got the 3-year work authorizations, and it started to explain to them that they weren't getting 3 years, they were getting the 2 years as they were supposed to.
Each and every one of them, Congressman, was sent a letter advising them of the error, directing them to return their 3-year authorization, and advising them that they would be given a 2-year authorization. As I indicated, we have already recaptured a number of those 3-year work authorizations and are issuing 2-year authorizations.
All right. Well, Director Rodriguez, this here is Washington, D.C., and we don't blow anything out of proportion here.
Oh, no, sir. Never, never.
But, nevertheless, some reports have indicated that the USCIS intentionally failed to comply with the Texas Federal Court's injunction. Director Rodriguez, I just want to clear this up once and for all. How would you react to those criticisms?
Congressman, I'm a public servant. I am an officer of the court as an attorney. I think you've already observed we actually owned up to the error that we had made. That makes it fairly clear that the intent all along had been to comply with the court's order.
All right. Now, as it currently stands, are you moving forward with plans to process DAPA applications at that facility?
In absolutely no respect, Congressman. As I said, we immediately, literally within minutes, halted all activities that amounted to the implementation of either the expanded DACA or the DAPA program immediately upon the court's injunction. No policies have been developed, no people have been hired, nothing has been done to implement those programs.
Well, I thank you for your work, and I yield back.
Thank you, Congressman.
The gentleman yields back. The chair will now recognize himself for 5 minutes. I do appreciate your service, and when we've had you here in hearings before, it is obvious that you serve administration to administration in attempts to make our system both lawful and to secure our country. However, that doesn't necessarily negate the fact that we still have problems. As Mr. Lynch pointed out earlier about those that were enlisted on fields of battle to gain their citizenship, I just might point out, having commanded some soldiers in foreign fields in that category, that they were legally here in this country and had been properly vetted with no criminal histories. And that's the essence of what we're getting at here today, is within the constructs of enforcing the law and doing these things that we must do, we can't just let policies, political, regardless of administration, take away our immigration process and result in the crimes that we're discussing, penetration of our borders that weaken our national security and could open us up even to terrorist attack. Mr. Roth, is it correct that the department does not collect and analyze data on the use of prosecutorial discretion?
That's correct.
And can you explain why this is significant?
Yes. It's best to do it by example. For example, if ERO officers go into, say, a house to look for a specific violent felon, there might be 3 or 4 other individuals that would be susceptible to deportation. By the fact that those officers exercise prosecutorial discretion on those individuals means that really it's invisible to the policymakers as to, one, who's exercising prosecutorial discretion and why. Is it uniform across the country? Should it be uniform across the country? Are there categories of individuals for perhaps we should not exercise prosecutorial discretion? In other words, try to refine the policy as we go. It's really a fundamental sort of precept of good government that you ought to be able to record and measure the activities that you do.
Well, did the DHS explain what data it reviewed in setting those priorities for apprehension, detention, removal of undocumented immigrants, illegal aliens?
They did not, as far as prosecutorial discretion. Obviously, they capture a number of different data points of information with regard to the number of apprehensions, the number of deportations, those kinds of things, estimates of the number of individuals illegally in the United States, but they do not capture what we think is an important thing, which is the exercise of discretion.
And I think on this theme, you know, part of the concern is that these data gaps weaken our immigration enforcement efforts. Director Saldana, I have read reports where ICE agents have complained that they've not been able to access alien criminal history. And what is being done to take corrective action on criminal history record access to make sure that they can see the problem before it becomes a problem?
And actually, I've actually sat down and run through our data points and all the information that an officer may have available to them at the time of apprehension, book-in, whatever. And there is criminal information that comes through the NCIC and the FBI database with respect to prior convictions. I will say, Inspector General, that we agreed and concurred that we could be more systematic about our collection of data, but we do have a lot of information on the exercise of prosecutorial discretion. The issue I understood was it's not systematic, and that's what we're working towards. In other words, our lawyers, for example, because prosecutorial discretion can be exercised at any point of an immigrant's processing or going through the process, keep a record of when they exercise prosecutorial discretion. With respect to detention and bond decisions, that exercise of prosecutorial discretion is recorded. The issue is, and the reason we concurred with the ultimate finding was, we are currently working, and have been actually for several months, on systematically recording that information and consistently. You can imagine a law enforcement officer out there in the field trying to do his job, knocking on a door at 6 in the morning, and yes, they may not stop to
Well, I
note.
know you've had some efforts in the intensive supervision program, and that's laudable, but the problem is, what is being done to ensure that the intensive supervision program is maintained until the immigration status of the individual is determined? Right now, there have been identified gaps where that supervision is neglected before their immigration status is done. And why is that, and what will you do to correct that?
Well, actually, that's what I'm saying. I think we have, and I think it was noted in the report, we have the department itself, not the agency, has been working to make this systematic actually across all the agencies, this information database, and have committed to working that. I'm not even sure right now if I can remember where the report noted. The hope is that we can get that completed sometime this year. But that is a huge effort that is being undertaken by our policy people and our technical people, and I think it's very well underway. It just takes time.
Well, I appreciate those answers. Unfortunately, as time moves by, we see some drastic consequences. I am out of time, and I will now recognize the gentleman from California, Mr. Liu.
Thank you, Mr. Chair. I'd like to spend some time discussing an issue that's very important to me and to many members of Congress, and that is the continued detention of women, children, and infants in prison-like conditions. As you know, in 2009, the Department of Homeland Security shut down the Texas Hutto jail-like family facility because it was inhumane, because of reports of abuse and harsh conditions. So surprised in your testimony that you said your agency is opening up additional facilities. And that's particularly surprising to me because, as you know, the American Immigration Lawyers Association has stated that virtually all of these folks can qualify for asylum because they are fleeing terrifying conditions of violence, abuse, and crime, and they have a fear of removal. You also know that last November, Homeland Security Secretary Johnson wrote in a memo, and I quote, "Field office directors should not expend detention resources on aliens who are pregnant or nursing, who demonstrate that they are primary caretakers of children or infirm person, or whose detention is otherwise not in the public interest." So in light of that guidance, I'm asking, why does ICE continue to expend precious resources to detain thousands of families en masse, including children and infants in prison-like conditions?
Congressman, I want to be sure that I didn't misstate something. We do not have more new facilities that are being opened. We do have Dilley with additional space that was opened. It's the same residential center. We have 3 across the country, one in Dilley, one in Carnes, and one in Berks, Pennsylvania. But with respect to your question, we, up till actually the surge last summer and the spring, we had one facility essentially in Berks, Pennsylvania with 100 beds. We had to get going quickly to ensure that we had some place to put these families and the children, and in sanitary, good, humane facilities. I've been to both Carnes and to Dilley. I've toured the entire facilities. This is detention. It's not prison. I think, in fact, sir, that people have repeated the idea that there is barbed wire at our family residential centers and that the guards are armed. One only has to step into the facility to see that those claims are false.
Thank you. I think 135 members of Congress would disagree with you. In May 27th of this year, I joined them and signed a letter that said to Secretary Johnson, "We're troubled by the Department of Homeland Security's continued detention of mothers and children in secure jail-like facilities." and it describes some of what happens. We are disturbed by the fact that many mothers and children remain in family detention despite serious medical needs. In the past year, we have learned of the detention of children with intellectual disabilities, a child with brain cancer, a mother with a heart disorder, and a 12-year-old child who has not eaten solid food for 2 months. We also learned of a 3-year-old child who was storing up for 3 days and was apparently offered water as a form of medical treatment. It was only after the child began throwing up blood on 4th day that the facility finally transferred to a hospital. This is simply unacceptable. We cannot continue to hear reports of serious harm to children in custody and do nothing about it. So, Mr. Chair, I'd like to enter this letter into the record.
Without objection.
I also like to enter a letter in the record dated June 1st, 2015, from 33 members of the Senate that says similar things. And then I'd like to quote from this report, one of many, called Locking Up Family Values Again, a report on the practice of family detention by the Lutheran Immigration and Refugee Service and the Women's Refugee Commission. It opens up with a quote from the Advocacy Director of Human Rights Watch. Carnes was quite the visit for me. There's nothing like walking into a prison and the first thing you hear is a crying baby. Two things that should never go together, never, ever. So I note in your testimony that you call these facilities family residential centers. It is so positive sounding, it's like a place you might see at Disney World. These are actually jail-like facilities. They should be called, family prison facilities or family detention facilities or family jail facilities, but not family residential centers. And every time you use that term, you're misleading the American public. So I'm going to ask you, will you stop using that term and call it what it is?
No, sir. Have you visited one of our
Okay, so
facilities?
just know, now that you're on notice, every time you use that term, I believe you will now be intentionally misleading the American public, and I yield back.
I'm sorry you feel that way, Congressman. I'd love to take you through to one of our senators.
Me and 135 members of Congress feel that way, and 33 members of the Senate still feel that way.
The gentleman has yielded back, and the chair will now recognize the vice chairman, Mr. Mulvaney from South Carolina, for 5 minutes.
Thanks very much. Reset the clock, please. Ms. Saldana, who do you report to?
The Secretary of the Department of Homeland Security, Jay Johnson.
And then he reports to the President?
Yes, sir.
Okay, great. Could we run the video, please? You have a chance to follow along on the video screens for the next 2 minutes or so. Let me follow up on a couple different things. And you said before that there were communities and local governments that were denying you access. Tell me about that.
This is one of the challenges that I mentioned in my opening statement, sir, and I enlist the help of anybody that I can get help from on this issue. Because our biggest priority is criminals, convicted felons in particular, we need to work with state and local jurisdictions who are apprehending undocumented workers for offenses against state and local law. They have them in their custody. We can now communicate with the state and local jurisdiction and get some notice in advance through our detainer requests to let us know that they're about to release them because they've served their state custody sentence, and that we can take possession of them because of their violation of the law. And now we have a convicted criminal here.
But they're denying you the ability to do that.
Some jurisdictions are.
Why?
I can't speak for them. I will tell you it is, some of them have policies and laws that are telling.
Do you believe that you have and I'm sorry to cut you off, do you believe that you have the legal right to force them to comply with your requests?
We do not have, I cannot say that the detainer notices are mandatory. They are definitely discretionary.
Would it surprise you if the administration had taken a different position on that in the recent past?
Well, we've argued that, and there's pending litigation everywhere on this topic, and I think you may be familiar with the Oregon case. But we do not. We are trying to work. We're interested in the outcome.
Would it help you if we clarified the law to make it clear that it was mandatory that those local communities cooperate with you?
Thank you. Amen.
Okay.
Yes.
Thank you. That was Thursday, March 19th. Before the papers got printed the next morning, you had retracted that statement. And you went on to say that any effort of federal legislation now to mandate state and local law enforcement's compliance with ICE detainers will, in our view, be highly counterproductive. So my question is, after you gave that testimony, did you talk to Jay Johnson or anyone in his office?
Yes, I have.
Okay.
And
No,
that-
I'm talking about, let me be more clear. Between the time that you gave that testimony and the time you retracted that statement later that afternoon, did you talk to anybody at Jay Johnson's office?
Yes.
What did they tell you?
What did they tell me? They asked me what I meant by that, and that's what my statement was. It was not a retraction, sir.
Oh, no, it was absolutely a
It was,
retraction.
it was a clarification of the fact that I'm used to the law enforcement.
I can play it back again, Ms. Saldana, if you want to, but everybody here knows it was a retraction. That's fine. There's nothing wrong with retracting statements. People do it all the time. But I asked you if you'd like some help in getting the localities to cooperate with you. You said, thank you, amen, yes. And we all said, well, great, we think we can do that. And that night, you said, any effort to do that would be counterproductive. And I'm asking you, did Jay Johnson ask you to change your statement?
He did not.
Did anybody else ask you to change your statement?
Change this, no.
Okay. Did Jay Johnson ask you to clarify your statement?
We discussed a clarification to make sure people understood that we need to work with state and local governments to ensure public safety in our community.
So when I asked you if we could help you by requiring state and local governments to cooperate with you, and you said, thank you, amen, yes, that meant thank you, amen, no. Is that what you're telling me now?
No.
Do you still want us to help you force the localities to cooperate with you on turning over criminals to your agents?
Sir, the forcing part is the issue. The forcing is not going to bring these people to the table. It's the efforts of all of us to make clear that this new program—
Would you like us to pass a law that would require local governments to turn dangerous illegal immigrants directly over to ICE?
No.
Why not?
Because we're in the middle of, not only myself and our employees at ICE.
You've
but
given
the—
testimony that
May I
says—
finish,
No,
sir?
you may not. You've given testimony that says that one of the reasons you're concerned about the lack of cooperation is the safety of your agents. If we were to pass a law that would require towns and cities to turn dangerous criminal illegals directly over to your agents, would that make your agents safer?
We're working right now with those state and local jurisdictions in
Great,
order to
great
get
answer
to
to
that
a
same
question
place.
that I did not ask. If Congress were to pass a law to do that, would your people be safer?
If you passed a law requiring them,
Yes.
I don't know that can happen, sir, because we're in the middle of
I
discussions
didn't ask you
with
that.
state and local.
If we did it, would it make your people— we all know the answer, and the answer is yes. So I won't get a chance to ask you the last question, but the question is this, is that apparently either you or Jay Johnson wants to put the politics ahead of the safety of your people, and I find that absolutely unacceptable. Thank you, Mr. Chairman.
The chair now recognizes the gentlelady from Illinois, Ms. Kelly.
Thank you, Mr. Chair. Ms. Saldana, would you say what you wanted to say?
Yes, and that is, my interest is in public safety and the safety of our officers. And if we are allowed a period of time to work with state and local jurisdictions in order to accomplish what I hope this committee wants to accomplish, and that is removing serious criminal convicted aliens from the United States, then that's what we're working towards. And that's how we got Los Angeles to say they'd cooperate with us, and Contra Costa as well in California, and we're working with several other jurisdictions. Always best to try to get people to come to the table to discuss matters than to force things down their throats.
Okay, thank you. Mr. Roth, I have reviewed your report from last month on the department's need to strengthen data collection for its enforcement efforts. I think we all agree that ideally DHS would always be collecting more, not less data. I'd like to explore how this can best be done when resources may already be stretched thin. Last November, the department's memo on exercising prosecutorial discretion stated, quote, "It is generally preferable to exercise such discretion as early in the case or proceeding as possible in order to preserve government resources." Director, do you agree with that?
Yes.
And can you explain specifically how the use of prosecutorial discretion helps preserve ISIS resources?
As I testified earlier, I am, up till December 16th or 22nd, I was the United States Attorney for North Texas, responsible for 100 counties, working with 100 different jurisdictions locally, as well as local police departments. I had the responsibility for over 3,000, the enforcement of over 3,000 federal statutes as a United States attorney. There is no way with 100 lawyers that I could bring to bear enforcement of all those laws. So part of my job, and it's a difficult part, is deciding which cases will have the greatest impact on community safety, because I can't take every one of them. That is the very reason why these executive actions that the Secretary announced on November 20th are essential, because we have a multi-billion-dollar budget, almost $6 billion, but there are 11.5 million people in the country unlawfully. We have over 2 million in process at one stage or another of immigration proceedings. There is no way, I would think, that this committee would support funding the removal of each one of those, because it would cost billions and billions of dollars. So prosecutorial discretion is just essential.
And how frequently would you say a typical ICE agent exercises this discretion on the job?
It's every day. It's a part of their job. And they come across different situations at all times. So,
Thank you. Mr. Roth, in your written testimony, you said given the sheer number of removable aliens and the finite resources available to remove them, DHS has decided it must focus on those who pose the greatest risk. As a former prosecutor, you use prosecutorial discretion many times, isn't that right?
That's correct.
Would you agree that this discretion involves making judgment calls?
Absolutely.
And Mr. Roth, in writing the May 4th report, did your office conduct a cost-benefit analysis as to how more discretion data would improve enforcement outcomes, and why or why not?
We were not able to, simply because we don't know how often prosecutorial discretion is used. I think, as Director Saldana noted, we know how much is used later on in the process when ICE lawyers, for example, take people out of the system. The thing that we don't know, and we think we should know, and the Department agrees that they should know, is how often that discretion is exercised at the very point of encounter, which, as you know, would be the most cost-effective way to do it. But until we actually understand what we're talking about, it's impossible to do a cost-benefit.
So DHS responded to a draft of the Inspector General's report by stating this data project will, and I quote, provide a framework for measuring and evaluating the Department's enforcement actions from a range of perspectives. Is it fair to say that sometimes the use of this discretion can be difficult to quantify?
The number of times you use the discretion should be able to be quantified. Now, the reasons that you use it or the judgment that is used is obviously something that will vary depending on sort of what situation the officer has. But the raw numbers themselves, and if I could just use an example, we wrote an audit of the workforce enforcement that ICE does. And there they do collect statistics. And one of the things that jumped out at us in that audit was the fact that, for example, New Orleans, 5% of the time imposed fines, yet Chicago did it 35% of the time. Raises the obvious question, how is Chicago different than New Orleans? It might be perfectly appropriate, but it certainly raises questions that you'd want to ask. So until you collect that data, though, you're not even going to be able to understand which questions you should ask.
I'm out of time. Thank you so much.
The chair now recognizes the gentleman from Georgia, Mr. Heiss, 5 minutes.
Thank you, Mr. Chairman. Ms. Saldana, do you have any idea how many convicted criminals have been arrested by ICE this year?
I believe that number, excuse me? Oh, I'm sorry. I believe that number is, let's say for 14, it's 177,960, about 56% of those that were removed from the country. Are you asking for 15 thus far, sir?
Yes, ma'am.
I don't have that readily available, but I'm happy to provide it.
I would appreciate that. Well, then, would you have any idea how many have been released this year?
This year we have, I think, somewhere in the neighborhood of, actually, I don't have that number, sir. I don't have
Okay,
that number.
so I'm assuming then you don't have any projections this year from previous years?
For
Or how many
release
are
of
going to be
criminals?
arrested, how many are going to be released?
No. Projections?
Yes.
No,
Okay.
we don't.
Well, based on the last couple of years, there's been over 50,000 released. So it would be my assumption then we will continue down that trend. Last time that you appeared here, I had spoken to the sheriff of Gwinnett County, Georgia, which is one of the top 5 counties in the country, dealing with the problem of illegals being released in their county. I was told by the sheriff before coming in here that his department has had no communication whatsoever with Homeland Security or ICE before criminals have been released back into his county. We spoke about that, and you assured me that you would start informing local law enforcement agents when criminal aliens are released back into their communities. Is that system, and in fairness, you said you didn't know when that would occur. My question, is that system in place now?
Well, I think what I said was it is not systematic. We have relationships all over the country where people pick up the phone and call each other. What I want is a systematic process. That's what I'm always interested in, establishing systems and procedures that will assure that. That's what that law enforcement notification system is about that I mentioned in my opening statement, LENS, which we have tested already in Texas, Louisiana, and one other state, Virginia, I think. Those 3 states. And we plan to have all the states connected to a systematic notification system by the end of the year.
Well, your comment to me was that your department, your agency would be informing local law enforcement agents and departments when you release criminals back into their communities. And that is not in place still.
That has begun, sir, in 3 states, Texas included, where we have a substantial amount of activity.
Okay, when is it going to be completed throughout the rest? I want to know when, next time I call one of my sheriffs, that they will be able to say to me that you contacted them, your department contacted them when thieves, murderers, rapists, whatever, have been released back into their communities.
As I said earlier, by year end, we should have the entire country covered. And your department will get a phone call this afternoon.
Okay, so you are saying to this committee that by the end of the year, every local law enforcement agent throughout the country will be notified before an illegal is released back into their community?
The way I described it, sir, it is a notification system that goes to the state. You know, we can't, I don't know, we have 254 counties in Texas, which is a large number. What we ask them to do is to connect up with the state notification system. We give the information to the state, and the state has already in
So
place.
local law enforcement will not be notified, the state will. And so it will be left to the state to communicate it abroad.
Yes, and we're discussing it with the governors of those states and the people who implement the system. They're more than happy to do this.
Does ICE or any other agency in our government monitor the activities of criminals following their release?
Many of them are released with conditions, including supervision, reporting in, ankle bracelets, other conditions that are imposed in making the decision to release somebody under those conditions.
This is an issue that I think people are sick and tired. Americans cannot fathom, cannot understand why illegal individuals in this country who are repeat offenders of crime are continually released back in their communities. They shouldn't be in the country in the first place, let alone walking freely in our communities to the tunes of tens and tens and tens of thousands. And Mr. Chairman, I just express my great concern with this, and I yield my time.
The gentleman yields back. The chair now recognizes the gentlelady from New Mexico, Ms. Lou Ann Grisham, for 5 minutes.
Thank you, Mr. Chairman. I'm going to talk about a couple of folks in my district. One young woman, Yuridia Loeta, was brought to this country when she was 2 years old. She currently attends the University of New Mexico, my alma mater. Because of DACA, frankly, she was able to travel to Nicaragua and volunteer at a nonprofit for underprivileged children. Now, Yuridia wants to attend medical school and provide health care to underserved rural communities, and given that that reflects the entire state, and we are in dire states, straits currently about making sure that we can meet just primary care access issues pre-ACA, during ACA, and the growing number of minority individuals in a minority-majority state. This is a wonderful thing in a state like mine, and I can tell you in the Southwest in general. Another woman, Marian Mendez Seta, is a senior at UNM, and she's studying psychology and philosophy with a concentration in pre-law. And maybe she'll go to my law school also at the University of New Mexico. She comes from a low-income family, and because of DACA, she's able to work to not only pay for her school, but she helps her parents out financially as well. I do the very same for my mother. Very strong cultural values in my Hispanic community. Now, Chairman Chafis, I think, did an interesting thing in this committee, and we're looking all around us at these beautiful walls with images of hardworking individuals who are dedicated to their work and their families and their communities. Considering that Congress failed to act on comprehensive immigration reform to ensure that everyone has the opportunity to work, learn, and contribute to the country, I support, frankly, the President's actions on immigration. However, I have heard several concerns about inconsistencies in how the President's actions are being applied. Immigration advocacy groups have been tracking reports concerning violations of the priorities memo, and after receiving hundreds of phone calls, they are hearing that ICE field offices may not be applying the priorities appropriately. Furthermore, on April 15th, over 100 organizations wrote to DHS Secretary Johnson expressing similar concerns. That letter states, and I quote, "We have received numerous reports indicating that several ICE officers are failing to comply with the priorities memo. Even people who do not fall under any priority whatsoever have been removed." Mr. Chairman, I'd like to enter this letter into the record.
Without objection.
Thank you. On top of this, we have most recently heard concerning reports that ICE may be mining DMV databases to target low or non-enforcement priority individuals, issues that I heard about well before I was elected in 2012, not particularly related to this priorities memo, but consistent in patterns and practice that I find not only very concerning, but offensive. Even as we speak, immigration advocates are fasting in protest at ICE headquarters just down the street over ICE's failure to apply prosecutorial discretion in line with the memo. Director Saldana, these mounting reports are extremely upsetting. Can you explain to me the inconsistencies and how the priorities, frankly, are being applied on the ground?
Yes, of course. As a matter, again, we're talking about priorities and the fact that decisions on even arresting, removal, bond, are all made on the basis of these priorities and the judgment of the persons of all.
So you're arguing that there are no inconsistencies, because so far your statement to me is that that's being applied consistently, correctly, and adequately. I just want to make sure I'm following you.
No.
Okay.
Sorry, I didn't mean to say that if I did. What I'm saying is every case is different, Congresswoman. Every case is different. We have specifically trained all our folks on the legal side and on the officer side to look at all the facts and circumstances of that matter. So if
I'm going to reclaim part of my time. So does that mean that you don't think that, do you agree that you're applying the priorities memo effectively? Because I don't think that you are, and what I really want to know is what you can do to assure me in this committee of your full compliance.
As an example, the perception is not the reality. 96% of the people we currently detain in our facilities meet priorities 1 and 2.
I'd have to say that I don't believe that that's accurate in my community, and I will demonstrate that in a much more direct way, and I would like, Mr. Chairman, for that to also be included as part of the record.
Without objection, and the gentlelady's time is now expired. Votes have just been called. However, I do believe that we will have time to get through the next two members' questions. And with that, the chair will now recognize the gentleman from North Carolina, Mr. Walker.
Thank you, Mr. Chairman. Obviously, today we are talking about a very emotional issue. This goes beyond policy and really has to deal with human life. Very grateful for Mr. Roth, Mr. Rodriguez, and Ms. Saldana for coming in today. But I do believe that we've got to look at very closely as far as some of the problems that we're seeing. The gentlewoman from New Mexico just talked about a young lady from DACA and how it was working out for her. Let me tell you another example of someone from that was released even after a drug charge. A gentleman by the name of Emmanuel Hernandez in my home state of North Carolina murdered 4 people. This was after he was a known gang member and after he was picked up with a drug offense. Applied for DACA and his deportation was halted. Now, Ms. Aldana, earlier you brought in a book and laid it there on the desk. The book basically is the Immigration National Act. Now, I don't know if you're familiar with Section 236C, which is basically the detention of criminal aliens. Are you familiar with that section at all? Well, let's take a look at that, and I'll read what it says. It says the Attorney General shall take into custody any alien who is inadmissible by reason of having committed any offense covered in Section 212 and is deportable by reason of having committed any offense covered in Section 237. There's 4 offenses under that: aggravated felony, controlled substance, firearm possession, and espionage. That's custody. Now let me jump to the section that's number 2, it's release. It says the Attorney General may release, okay, only, very key word, only if the alien satisfies the Attorney General that the alien will not pose a danger to the safety of other persons or of property and is likely to appear for any scheduled proceeding. Now, what's confusing to many of our American citizens is why the lack of consistency here. So my question for you today is, can you guarantee, is it safe that the most serious non-citizen illegals and aliens who have been recently ordered to be deported, will they be removed under the President's executive actions?
They will, sir, but with respect to those that are under an immigration court, I can't predict what the immigration court will do. And of course, that's a large portion of the people that come through our proceedings. They end up claiming some exemption or seeking asylum or something. Their considerations are with USCIS and with the immigration court.
But according to the Immigration National Act that you brought in, and the paragraph that I just read under release, that contradicts what the Attorney General says as far as grounds to be released. Do you see the contradiction in that?
We're talking about the mandatory release provision, mandatory custody provisions?
Yes.
We abide by those.
Okay, then please tell me why there is a growing number, millions of non-citizens continue to remain in this country illegally, of which some obviously are criminals. How does the department expect to address this increased danger to our citizens? Tell me what's being done proactively to follow basically the letter of the law by the Attorney General.
Let me mention my guidance to the field in March 13th. I've actually visited with all the field office directors, there's 26 of them, I believe, across the country, and have advised them how it is that we're going to go about our business, and with respect to the considerations for any individual being flight risk and safety, public safety. It's just like any bond decision that a court would make. And we've trained them accordingly as well. And then I want to point out the fact that I've established this system back in March, which specifically sets an extra enhancement of supervisory approval over any release of a convicted criminal that's being considered by a supervisor with a sign-off, by a pool of experts that I have at headquarters who come in and review all of these releases. I'm talking about March of 2015. The data that has been quoted has been information relating to fiscal years 8 through 14. I can't speak for what happened then, but I do know that we take this very seriously at the agency, and that's why I've instituted that additional supervisory review of release of criminals.
Final question before we run out of time here. What is the recidivism rate for all aliens who are were previously apprehended, subsequently released, and who have committed a new crime? Do you have that number?
I don't have it with me, but it's very low. I mean, compared to certainly the recidivism rate in the general criminal.
Would you like to take, is there a round number that you would like to suggest what it is?
I can't. I won't speculate, sir. I can provide that number.
Thank you, Mr. Chairman. Yield back.
Gentlemen, or I'm sorry, the chair now recognizes the gentlelady from D.C., Ms. Norton. And I would ask for brevity so that we can accommodate the last 2 members here.
I will remember that, Mr. Chairman. There's concern in the District of Columbia because the D.C. Council passed a law. It allows driver's licenses. There have been some reports in the papers about ICE's use of DMV data to initiate removal proceedings against immigrants. I would have some concerns, and I'm wondering if you can tell me whether DMV databases are being used for removal purposes.
Not for removal purposes, ma'am. I will tell you, since I've been in this position since January, I have had to run down more allegations and reports in the media that end up yielding a case quite contrary to that which was reported.
Well, you do have access, though, to these databases?
We can check in with the departments of public safety of the different communities, may be required as a part of an investigation, for example, but not for removal purposes.
So you have to be granted them by the jurisdiction?
I'm pretty sure that it's the Department of Public Safety itself, whatever jurisdiction we're in, that maintains that, and we would communicate with them to see if we could get that information.
And if they wanted to refuse them, they could?
Yes.
That's very important to clarify. Mr. Chairman, I have here and would like to ask be entered into the record the briefs filed in Texas versus the United States. There are 15 states plus the District of Columbia that have filed briefs in this case, who say that there would be improvement in their own economies, and I ask that these briefs be entered into the record.
Without objection.
Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. The chair now recognizes the gentleman from Georgia, Mr. Carter, for 5
Thank you,
minutes.
Mr. Chairman. Ms. Sedona, Mr. Walker asked you earlier about the recidivism rate for aliens who were previously apprehended, subsequently released, and who have committed a new crime. You said you do not have those numbers available?
We have looked at them because we had this question
Okay.
previously, and I just remember that it was comparative to the regular criminal
All right.
justice
Can you
system.
provide this committee with
Yes.
those numbers, please?
Absolutely.
Okay, Mr. Chairman, will you note that those numbers will be provided to us?
So noted.
Thank you. Thank you. Mr. Roth, in your report you found that ICE field officers said that they might not have access to an individual's criminal history or their country of origin. Is this correct?
The criminal history in their country of origin. For example, if it's a Mexican national, they may not be able to have the criminal history that may have occurred within their country of origin.
So what happens when an ICE field agent doesn't have this history?
Well, they're not able to evaluate it in the use of their discretion.
Do other ICE officials have that information?
This is a vulnerability that we found during the course of our field work that we notified ICE of, but my understanding is largely the answer is no.
Why would the field officers not have that information, but some of the other officers may have it?
Well, I'm not 100% sure as to which countries and what parts of ICE may have access to that information.
Ms. O'Donnell, why would some of the ICE field officers not have access to some of this information?
Well, it needs to be provided by the country and by the country in question, and some countries are more cooperative with the United States than others.
So we just depend on them to give it to us. We don't demand that they give it to us?
Oh, we can demand, but there's not much we can do. I'm working with the Department of State to try to help with respect to countries that have been recalcitrant in their cooperation with us to urge them to assist us. I even went to China a couple of months ago to sign a repatriation agreement, which was a very notable event where they agreed to come to the United States, send 2 people to the United States to actually assist with repatriation. So we're making inroads, but diplomatically, it's a huge world.
I understand, but how can we expect the ICE field agents to apply prosecutorial discretion without access to those records? I mean, that's a lot to expect out of them, don't you think?
Yes, it is, sir. And again, as I said earlier, every decision we make on custody bond, decisions to remove or put someone in immigration proceedings is made on the basis of the information we have available. That's
So what if the information is not available? What do we do then?
if, with respect to other countries, we can try MLAT, our procedure through countries asking for information regarding a person's criminal history. We can try gentle persuasion, but when push comes to shove, you all have provided, the Congress has provided for certain punitive measures to be taken against recalcitrant countries, but that's something the Department of State is involved in.
Okay, so we ask the illegal aliens, we ask their country for their criminal records.
Yes.
But we don't always get it.
Right.
And if we don't get it, then we're just, we can't use discretion. We don't, I mean, I really, we want to do everything we can to give our field agents the opportunity to perform their work and to do their duty. Yet if we can't get the information, I don't know how we're going to do that. Would you agree? I mean, that's a real problem.
It is a real problem, and we certainly appreciate any help this committee can provide.
What can we do? Tell us what we can do to help you.
Well, I mean, I think there are statutes on the book that provide for working with our countries, and when they don't cooperate, perhaps going further with respect to some punitive measures, but that's not something ICE does. That's something the Department of State is charged with, the laws that you all, the Congress, has passed with respect to that.
Okay. Mr. Chairman, that's all I have today. Thank you. I yield back.
The gentleman yields back, and I would like to thank our witnesses for taking the time to appear before us today. Seeing no further business, without objection, the subcommittee stands adjourned.